Good morning, and thank you for watching the law offices of Brent Williams-Ruth. I am Brent Williams-Ruth, and I'm coming to you today on August 17th, 2023, and I'll explain why that's important in a minute, to talk about the appropriate safekeeping for original estate planning documents. Now, if you've seen my videos in the past, you know I'm an estate planning attorney licensed in Washington State. I'm giving the disclaimer and stating the date because I'm going to be talking specifically about a local court rule for the King County Superior Court that could change. And so I want to just make sure if someone's watching this 10 years from now, make sure you look at the rule. So many people say and think that putting your will into a safe deposit box is the best thing you can do. Wrong. Putting your will in a safe deposit box generally leads to exceedingly expensive fees before probate has ever began. And before you start saying, oh, I don't want to do probate. If you're watching this and you think that probate is the horrible, evil monster, look at my other videos that I've done either on this YouTube channel or on my Facebook page. Because in Washington State, probate is not the evil monster that everyone should work to avoid. This is different in different states. So if you're from California or Florida or New York and you have heard horror stories about the process and not the families that make it horrible, because in Washington, the probate process is smooth, easy, inexpensive, and over in about 4.5 months if all your ducks are in a row. The only reason it would go longer is because you may have a taxable estate where you have to wait to get a green light to close the estate from the Department of Revenue or the Internal Revenue Service. That's not probate's fault. And that would happen regardless of what you have. Second, you likely have some family members that are dragging their feet, that are causing some problems, or your estate just wasn't actually ready to be administered right after someone passed. And again, that's okay. But I'm just simply saying, don't blame probate. Probate's this little process over here that people like to pick on, and that's unfair. So I'm going to read to you King County Local Court Rule 98.04D, as in David, and it's for for production of wills. And it says, upon the filing of any petition showing jurisdictional facts as to the estate of a deceased person and alleging that it is believed that a will exists and is in a safety deposit box to which the deceased had access, any person having control of such safety deposit box may be directed by court order to open such box in the presence of the petitioner, and if a document purporting to be a will of the deceased is found, the custodian of such safety deposit box shall deliver the same to counsel for the petitioner for immediate filing or to the clerk of the court. Now I'm going to spend some time dissecting this and what this means. Number one, who is the petitioner? Petitioner is anyone that thinks they may be the executor. Could be a family member, could be best friend. Doesn't matter. If someone says to you, Bob, I've named you the executor of my will, that is enough for you to try and get this court order to open a safety deposit box if you can't find the will and you believe it's in the safety deposit box. Now I'm going to do a timeout and talk about why this rule is in place, especially if you say, well, gee, Brent, I have a power of attorney, and so I'm allowed to go to the bank and do things. Yes, until the person who gave you that power has died. Immediately upon the death of the principal, a power of attorney is no longer valid. So you go to a bank and say, hi, I need to get into Bob's safe deposit box because I think that's where his will is and he's dead now. They'll be like, oh, great. Well, your power of attorney is worthless. So sorry, we can't let you in. And so that's where this court rule comes in. Now let's go and talk about who is the custodian or person having control. That's going to be a bank manager, bank employee. They are the custodians of the safety deposit box. So what happens is If you think you're the executor, you go to an attorney, say, hey, I need to get an order to get into the court, to the safe deposit box. And they fill out the appropriate petition, file it with the court, and it just says, hey, court, this person over here, they believe they're the executor. They believe it's here at this bank, and it's at Home Street Bank on 6th Avenue, safety deposit box number 1234. And we need a court order granting permission. The court says, great, thanks so much. And again, you have to prove the person's passed away, so they'll want to see a copy of the death certificate. You get the order. You then take the order with the petitioner and the attorney to go to the bank. And you say, hi, bank, we're here. We have a court order. We have the key. Or if you don't have the key, but you know that they have a box there and you can't find it, they will have the box drilled at your expense. And usually you have to coordinate. If you don't have the key, you actually need to call the bank and say, hey, bank, I don't have a key. I know that Mr. Johnson had a safety deposit box there, and I'm getting the court order that'll allow you to open it. And when can we arrange for that time for somebody to show up? And they'll say Tuesday at 2:00. And you're like, great, we'll see you then. So you show up, you give them the court order. They verify that the person there, the petitioner, is the one asking to be let into the box. The attorney is there as the officer of the court, because as the bank goes into the vault and pulls out the safe deposit box, they are then going to open that box and look through it. Let me reread this again. Any person having control of such safety deposit box may be directed by court order to open such box in the presence of the petitioner. So that means that they open the box with you. You don't get to go in and be secret. This isn't like you just going to view stuff on your own in your safe deposit box where they, walk away and leave you there. No. They're there and they're going to be watching you go through and pull everything out. And again, you're not allowed to take anything except the will. And then if something that is found, a will is found for the person from the safety deposit box, then the bank gives that will to the counsel/attorney for the petitioner. Because I am an officer of the court. In addition to being licensed in Washington, what that means is that I've sworn an oath to uphold the laws and the Constitution of the state of Washington and of the United States. And that means I have extra duties and requirements. And so, and the reason is, if a bank gives the petitioner the will and they don't like what's in it, or they're afraid of what it's going to say, they may make it disappear. So they give it to the attorney. The attorney then takes it directly to the court for filing and putting it for safekeeping and beginning of the process. Now, if you've ever had to work with an attorney that charges by the hour, what I have just described is a process that costs anywhere from $1,800 to $3,200. And that's before you've even done probate. Most probates for my easy families are done for less than $5,000. Again, it depends on how many total calls and all the things that go into it. But when you put a will into a safe deposit box and die, then you have just spent a ton of money before ever actually administering the estate. I had one where I worked with a bank that I won't name, but I don't work with them anymore. And I tell my clients not to work with them. And the bank manager refused to follow the rules. I mean, it was the most insane thing. I literally had the court order and like, nope, sorry, won't do it. I'm like, you're violating a court order. Am I going to have to go and get a contempt order from you? And they were taking up so much time that we were literally just sitting there with my client, and I'm on the clock. And I hate charging for it, but if someone else drags out the process and what should have been an easily scheduled appointment and done in 10, 15 minutes and they drag it out for 2 hours, that just adds to the cost. Banks and financial institutions really are the bane of my existence when it comes to estate planning or estate administration, because they are so afraid of their own liability. And if the person isn't known to the bank, it just causes severe delay and expense. So, what's the option? My recommendation to clients is that you should just keep your estate planning documents at your house in a nondescript place, but let people know, let your executor know where your wills are, because having the original will is critical to smooth administration. Now, is the game over if you don't have an original will and you only have a copy? No, it's not. But that just adds, again, expense, hassle, and inconvenience into the administration of what otherwise is easy. It must be the original will, signed by the decedent, witnessed by two independent people who aren't related to the family, who aren't getting anything in the will, and then notarized. That is what a will needs. So, can you make a scan of a will? Absolutely, but a scan is still a copy. So it's fine to do that, and it's fine to have an electronic version, but you need to keep track of your original documents. Now, for me, with my clients who are part of the concierge lifetime relationship, I actually do a double execution. I keep one original copy of their signed will, but I also don't like the practice that many old-fashioned law firms do, which is to keep the original document and not send an original to the client. And the reason they do that is because it's very easy as an attorney to have that decedent's family call you and say they've just died. And you're like, oh, I'm so sorry. We can take care of all that for you. And you don't feel comfortable saying, no, that's okay. We don't need your help. We've got someone else or whatever. I never want to tie my clients to me. My clients are my clients because they want to be my clients, and we have a relationship where they want to continue working with me. Because I send them home with their own original copy. I keep an original copy that is kept in long-term storage and archival. So if I find out somebody's passed away, I contact the archival company and say, hey, I need to pull the file from this box. And it comes to me. And if the family can't find it, and we know because they just moved into an assisted living facility. This is a real story happened. There was a quick move into an assisted living facility, a lot of downsizing, and things were just lost and thrown away into trash. But they were still my client. And we talked before they'd passed away, and I said, well, do you want to execute another will so you have a second copy? And they said, no, it's okay. They know that I have my copy. It hasn't changed. It's all good. And so that's where I work with my clients differently than many other attorneys. But the bottom line is, by putting things in a safe or safety deposit box, you're going to spend hundreds, if not thousands of dollars before you even pass, roll that first dice and go past go. You have to get that before even starting. And it's something that breaks my heart. I hate having to do it. But again, it's something that can take. Getting a will out of a bank has taken more time than all the legal time I need to spend with a client administering a will. That's how lopsided that process can be. And working at a different bank can be huge, which again is one of the reasons why I encourage my clients to do all of their banking at financial institutions and work with financial advisors that know who they are, that know their families. So that way, the people you're going to work with, yeah, they still have rules to follow, but they're going to know who you are. They're going to know your family. They're going to work with you to get all of the compliance matters taken care of. Back in my day, I once upon a time worked for a large bank, and as a banker, I could verify somebody's identity because they're known to me. I know who they are, and I know their families. And so it makes a difference. And though it may be a pain in the butt to move away from that credit union or that bank that you've been with for 25 years, I will tell you that life can change and be a whole lot easier if you're at a place that treats you like your bank may have treated you back in 1982. All right, that's it for today. Have a wonderful day. Again, if you or anyone you know is in the Washington State area that needs assistance with estate planning or estate administration, it'd be my honor to talk with them. Consultations at this time are still free of charge, could change in the future, but as of right now, you've got questions, call my office, 253-285-7751, and I'm happy to talk with you. Take care.